Hi, my name is Helen Tarokic. I'm a North Carolina board certified immigration law specialist and immigration attorney licensed in the state of North Carolina. Our law office is based in Wilmington, North Carolina. Hola, soy la abogada Helen Tarokic. Nuestra oficina legal está en Wilmington, Carolina del Norte. Soy certificada como especialista en asuntos migratorios por el estado de Carolina del Norte y soy abogada licenciada. Estoy aquí para tratar de contestar sus preguntas hoy. I'm here to try to answer your questions. Now, I'm not sure if we're going to do questions and answers all in English. There might be some questions in Spanish. I will do my best to try to get in the question and answer in both languages. Sometimes it'll be a summary, not a perfect translation, but I will do my best. So today the goal is to talk about U visas. And of course, I can try to take some other questions as well. But one of the things that I saw in a lot of social media posts was just that people were really confused about whether they can even pursue a U visa. What happens if one department refuses to sign a U visa certification? Can you ask a different department in the same area or a different law enforcement agency? And also, is the U visa the best method to actually pursue immigration status compared to other humanitarian options? So please feel free to put your questions in the chat. And I'll do my best to read the questions in the chat out loud and then present on the answer. During this broadcast, you can support our page by sending stars. If on Facebook, it's a digital gift that helps us improve our program. Also, of course, on Facebook, please like and follow. And if you're watching us on YouTube, please like and subscribe. The more reach we have, the better we can do. Okay, so en español, vamos a say the same thing in Spanish, pretty much. So, básicamente, durante esta charla, si quieren mandar estrellas, es un regalo digital que nos puede ayudar en promover nuestros programas o mejorarlos. También, si van a hacer comentarios en el chat, entonces puedo tratar de contestar sus preguntas o tratar de responder a sus comentarios. Vamos a hablar en inglés y también en español, así que si alguien tiene una pregunta en inglés, voy a contestar en inglés y de ahí voy a tratar de hacerlo en español también, siempre con un resumen, quizás no perfecto porque soy una sola persona, no soy con un intérprete al lado, pero trato de contestar en las dos maneras que puedo. So, while we're waiting for questions, I'm going to talk a little bit about a class action lawsuit that I hope is really going to help people who are pursuing U visas, T visas, and VAWA. So last year in 2025, when the Trump administration had put into play a new policy that was basically saying they were not going to ask victims if they have a victim case pending. So essentially, they would be blind to this, right? And so they would maybe pursue enforcement or arrest of an immigrant without asking or trying to become aware that the person had a victim case pending, like VAWA, a U visa, or a T visa. So that happened back in 2025. That was a huge change from how things were under President Biden's administration and also under even the previous Trump administration 1.0 and also under Obama. So this was a huge change from how things were. And it wasn't just that they would be essentially, not asking questions about if somebody was a victim, but there were concerns that once a person said, look, I am a victim and I have a U visa pending, or I have deferred action based on having a U visa pending, that they were still, in some cases, enforcing deportation without asking the right questions or giving people due process. And so in October of 2025, the Center for Human Rights and Constitutional Law, alongside co-counsel, public counsel, La Raza Centro Legal, and CHIRLA, the Coalition for Humane Immigrant Rights, sued the Trump administration to protect people with these pending cases, whether it was a U visa, a T visa, or VAWA. And in order to sue, they had individual victim plaintiffs who were survivors of crimes or other types of abuse, and they had either been detained or deported under this new 2025 Trump administration policy. Some of these people had formal deferred action, like permission to remain in the US, or a pending case that could have been approved. So this was a big deal. So the case is called Immigration Center for Women and Children v. Nome. Now it's changed, so it's v. Mullen. But this lawsuit basically challenged the Trump administration's policy on how to deal with victims when they were deciding how to move forward with enforcement or not. And so in our law office, we definitely wanted to help if we could. I certainly, the vast majority of cases of what I'm aware, our clients didn't have this issue, but that didn't mean that it couldn't happen. And we did participate to the best extent that we could related to supporting statements. Lots of other attorneys as well, basically from all over the United States, were doing what they can to contribute information where appropriate and under the rules of professional responsibility in order to help. And so just last week, just a few days ago, this incredible result came about that the judge has granted an injunction, which is an order to stop the memo, this policy memo, from being implemented anymore. So basically, there were a lot of arguments that were made. Some were under constitutional law, some were under the Administrative Procedure Act. In part, the judge certified the class nationally, basically saying that there was going to be this injunction temporarily while the lawsuit continued, so that all victims in the United States with pending TU or VAWA cases could have this protection. And it basically invalidated the Trump memo and said, for now, things are going to go back to how they were under Biden. Now, there may be an appeal. We could certainly expect there to be some type of appeal. But some of the results here are about ordering a method for people who were wrongfully deported under the Trump administration to be able to return to the United States. The idea being that if they were wronged, they should be able to come back. So I just want to say that when we are preparing victim cases, of course, we're advising about the benefits and the risks of applying for victim status and explaining the very broad and forgivable waivers or forgiveness that the government can give to people who were victims and are pursuing immigration status. But we also, of course, have to talk to people about what would happen if a case was denied. And there was this added layer about, well, what would happen if somebody was encountered by ICE? What did they say? Generally they have the right to remain silent, but if the government is blind to this policy or blind to their victim status, like they're not looking at it, or de facto revoking deferred action for people by just trying to, remove them from the United States, even though they have valid lawful presence, valid deferred action for victims, how do you talk to people about this? So, one of the things that became important was, yes, you do have, a right to remain silent, but at some point, if you're being detained, you may need to let the ICE officer know that you do have a victim visa case, either in preparation or pending with immigration, to try to trigger an important section of the 2025 Trump policy memo that said, once ICE is aware, even if they didn't want to ask because they were keeping their eyes closed, but once their eyes are open because you've told them, look, I'm a victim with a pending case, then they did have obligations. They do have obligations. First, they have to go through deconfliction, meaning they have to reach out to any agency investigating the victimization and make sure they won't basically mess up their investigation. They have to deconflict before taking any enforcement action. That would be something like before arresting, before detaining, before removing someone to the U.S. It also, even under the Trump memo, required that they seek guidance from a supervisor in these situations. And so even if they weren't required to ask, once they were told that a certain person had a victim visa case pending, then it did impose upon them various obligations, right? And so with that, this lawsuit is basically trying to put us back into a position where ICE has to check and provide affirmative protections for victims. So they can't be blind when they're trying to talk to somebody who is a victim. Instead, they have to make sure that they're giving these protections. So that means, for example, not just taking someone out of the United States, even though they have deferred action for victims. If they would like to have some type of revocation for some reason of their bona fide determination or deferred action, there are specific administrative steps they have to go to and through. And essentially, we're also looking at USCIS being the agency, not ICE generally, to be the one to try to end deferred action. So it's not that nobody can be removed from the United States if they have a victim case pending, but this is more about if you have a victim case pending, there are protections for victims in place. And if something unlawful happens and somebody is arrested and removed when they shouldn't be, then also there are court procedures to try to bring someone back to the United States. So some things haven't changed. If the government does something unlawful, then there are typically legal procedures to fix that problem, right? So I hope that this is helpful. I'm going to try to say a little bit of this in Spanish. And in the meantime, if you've just joined us, my name is Helen Tarokic. I'm an attorney licensed in North Carolina. If you have questions, please put your questions in the chat. Related to your questions, you can ask about U visas, U visa certification, victim visas, humanitarian visas. I'm trying to focus on U visas for today, but if you have a different question about immigration, it is okay to put it in the chat. I'll try to see if I can get to it as well. As always, please like, follow, and share. And if this program is helpful to you, we do always appreciate it. If you're on Facebook, if you can send stars, it helps us expand our reach. Okay. Entonces, vamos a hablar un poco sobre el caso nuevo que ha salido sobre protegiendo víctimas quienes están en proceso para un caso de visa U, un caso de visa T o un caso de VAWA, del Violence Against Women Act. Okay. Y entonces voy a abrir este lawsuit o demanda. Quiero estar mirándolo mientras estoy escribiéndolo porque es muy nuevo lo que salió la semana pasada, pero son muy buenas noticias sobre una orden de protección o injunction que han hecho en la Corte Federal en California para proteger a víctimas quienes tienen casos de visa T o VAWA pendiente y también para algunos quienes fueron deportados ilegalmente mientras tenían casos bona fides o casos pendientes en buena fe. Okay. Entonces, hace más de un año hubo una política que fue hecho por la administración de Trump. Y en esta política trataron de cambiar su procedimiento. Estaban diciendo que ya no iban, en 2025, ya no iban a preguntar si alguien fuera víctima o si tuviera un caso de victimización pendiente ante el Servicio de Inmigración antes de tratar de deportarlos. Así, básicamente estaban diciendo, somos ciegos, aunque lo podemos mirar en el sistema de migración, aunque muy fácilmente ICE puede ver que es una persona víctima. La política decía que ya no tienen que mirarlo, pueden ser ciegos, hasta que la persona diga, yo soy víctima con un caso pendiente. De ahí, si son informados que la persona es víctima oficialmente, tienen que comportarse con ciertas reglas. Una de las instrucciones de Trump era que por lo menos ellos tienen que verificar que la persona tiene un caso de visa de víctima como de la UT o VAWA pendiente. Okay. También ellos, si hubo algún reporte policial o investigación sobre la victimización, ICE tenía que cumplir deconfliction, donde es un proceso en el cual ellos tienen que asegurarse y comunicarse con la agencia investigando la victimización de la víctima. Ellos tienen que comunicarse con esa agencia para confirmar que no van a molestar la investigación de ninguna forma antes de mover la persona fuera de los Estados Unidos o antes de hacer algún arresto. Yo pienso que hubo arrestos sin preguntar si la persona fue víctima, aunque no fue casos de nosotros. Nosotros estamos vigilando las cosas que han pasado en todos los Estados Unidos, ¿no? Si somos notificados. Y también hubo situaciones donde alguien tenía acción diferida de víctima y todavía, aunque inmigración sabía de eso, estaban tratando de deportarles o ya lo habían deportado, así que estaban presentes legalmente en los Estados Unidos, pero ICE hizo esto contra ellos de todos modos. Otra cosa en este memorándum de Trump del año pasado, dijeron que ya no tienen que pedir agilización de casos de visa de víctima antes de mover a una persona fuera de los Estados Unidos. Así que hubo muy malo esta política que hicieron y fue completamente diferente de lo que existía por muchos, muchos años, más de 15 años antes. Y entonces la demanda fue hecho, una demanda contra migración, contra ICE, diciendo que ya no deberían hacer esto, que deberían de ser bloqueados, tratar de revocar acción diferida de víctima mientras gente tenía un caso pendiente. Este orden de protección también decía que migración ya no puede ser ciego, que ellos tienen que nuevamente preguntar si la persona es víctima y que, como siempre, tienen que también verificar con un supervisor antes de tomar alguna acción. Así que la regla bajo Trump tenía ciertas protecciones para víctimas, pero no mucho. Debido a esa nueva demanda que salió con esta orden de protección, entonces nosotros tenemos más protección y las protecciones básicamente han regresado como eran antes. Y las organizaciones eran el Centro para Mujeres y Niños, también la Raza Central Legal, también la Coalición para Derechos de Migrantes, es como, se llama CHIRLA, y también California Collaborative for Immigrant Justice. Así que hubo diferentes organizaciones colaborando en esta demanda. Y entonces el argumento era que víctimas merecen ciertas protecciones especiales para poder seguir con sus casos y que ICE debería de respetarlos. Especialmente cuando nosotros sabemos que hay protecciones constitucionales, nosotros tenemos que luchar para estas protecciones para nuestros clientes, pero es mejor cuando hay una orden de restricción contra el gobierno y desde la semana pasada esto ya existe, así que estamos muy felices en esto. Ok, entonces hay unas preguntas, so vamos a hacer estas preguntas, son dos en inglés, so voy a contestar primero en inglés. So Fernando Rodriguez, gracias. Oh, thank you so much for your question, Fernando. It's a great question. So can we take cases if somebody has not gotten their biometrics or receipts? So like for a U visa, a T visa, or VAWA, there are a lot of cases where the lawyer has filed the application correctly. It is not necessarily the lawyer who did anything wrong. It's actually USCIS. We still have situations from last year where receipt notices and biometrics for fingerprinting have not been issued by USCIS, or they did something like issued one receipt notice and then didn't issue the rest of them. So we're like, we know you got the case, but also each form that we filed has a special receipt number that needs to be assigned to it. Where are those receipts, right? So some of the things that we can do, yes, we do take those cases. I can tell you how we've been addressing it in our office, right? So, first of all, deep breaths, right? It's like everything just is slower and so frustrating now, and it's just hard enough to do our job. And now this receipt notice delay issue or fingerprint, like biometrics notice delay. So the first thing that we do, and this is something that people want to verify with their attorney as well, if possible, or if we're requesting a file from another law office, we're going to verify that as hopefully as part of our consultation process. Um, what we're trying to do is double check to see whether or not the application was delivered to the correct address at USCIS. Most of the time it was, but we just double check, want to make sure that something didn't go wrong or immigration kept changing where you could file things. So we did take on a couple of cases where it looked like the prior law firm had filed it in the wrong place. So we're always just double checking very carefully for was it filed in the right location. With T and U cases, there are no government filing fees, so there's no way to check to see if like the checks were cashed. We used to be able to check the back of the check for the receipt number. That was great, but not great that people had to pay filing fees. But now there are no filing fees for T or U visa applications, so there's no check to check, just the FedEx tracking, for example, to see if it was delivered. And then we could email USCIS. There's a hotline to check on that. And then also, we would do congressional liaison where we have our clients sign a Privacy Act release form. It's a permission form for the congressman or congresswoman's office to be able to contact Homeland Security about your missing receipts or biometrics. So an email and congressional liaison were some typical first steps related to this. And sometimes they'd find it, and sometimes months would go by and still no answer. It really created a lot of fear and paranoia. Again, it's hard enough to do our jobs, and now our clients are like, where are my receipts? You said you filed my case. I'm like, I know, we delivered it. So people get nervous, and I totally understand that. So we got to the point where we were already suing USCIS, filing lawsuits in federal district court to get them to move forward with issuing a decision on the first work permit, the permiso de bona fe, the bona fide determination work permit, or we were suing to try to get a full T visa approval. And we got to the point where I was like, look, if they have issued receipts and they have done biometrics and we're suing them because they still haven't given us the work permit or a final decision, why don't we just go ahead and sue as well if they haven't done the biometrics notices or receipts? I mean, that's really the first step to processing an application. It should not take 7 months to issue someone a receipt notice for an application that they filed. Frankly, it shouldn't take 7 months for them to give a bona fide determination work permit, but we see them taking longer and longer processing time. So if you have no biometrics notice issued yet for fingerprints, or if you haven't gotten your receipts yet, and we're talking months have gone by, you're probably at the point where considering mandamus, like a federal lawsuit to try to expedite the progress of your case, could be a good step forward. Not just to try to push the biometrics or the receipts, but also we're trying to push forward the adjudication of the actual work permit. Now, do I expect it to be possible that the government's going to push back on some of these lawsuits saying people should wait a year or they should wait 18 months before they sue? But sure, they can do that. But what is reasonable? Well, in 2016, there was official communication from USCIS saying they could approve a case in 3 to 4 months. That was their comments about bona fide determination. So why need one of those if you could get a grant 3 to 4 months? Well, as of a couple days ago, now they're saying 30.5 months to grant a T visa case in 80% of the cases that immigration is looking at. So those are very much slower processing times. And the bona fide determination process, we're seeing them in our office. Those work permits are typically coming within like 8 to 16 months right now. But that's of now. Maybe next month I'll start seeing them coming in at the 17-month mark, or we'll have cases where they will not issue it at all, and we're stuck waiting for the full T visa approval unless we expedite or sue. So if an attorney is saying, if we're saying also there's a situation where the attorney is not notifying the client that the biometrics appointment has been set and people are missing their appointment, that's like a separate question. So I appreciate that one as well. So obviously an attorney is obligated under rules of professional responsibility generally to notify people if they have an appointment, right? So if the communication is going to the attorney's office, they've got to notify the client that this appointment is coming up. So we obviously don't want to miss that appointment, because if you miss your fingerprinting appointment, it's going to have to be rescheduled. And if too much time goes by, USCIS essentially could deny the application for abandonment, which would be terrible for a U visa case, because that U visa certification was probably pretty hard to get or expensive to get. A lot of paperwork involved in getting those sometimes. And also because, you're losing your place in line if you abandon an application, you got to start all over again. So we definitely don't want anybody to miss a biometrics appointment. Very scary stuff. But what are we seeing? USCIS started being really slow to issue biometric appointments. And then some of the cases that we're seeing, we're getting notification days or weeks before the appointment. And the mail is very slow too. And so it's like it gets to the office, and even if we're like immediately calling our clients, texting and emailing, we try 3 different methods of communication so nobody misses their appointment, you still may end up in a situation where you have almost no notice of your appointment. Shouldn't be missing it generally. But so like, one of the questions I just have is, or I guess one of the things I would recommend is for law offices to make sure that they do mark down when the actual envelope arrived in their office, because sometimes you can see the stamp on an envelope is one date and the appointment notice had a different one. I've seen that with all kinds of notices with USCIS where they claim an order was issued on one day, but if you actually look at the stamp on the envelope, totally different day, like mailed a week later. So if somebody's not feeling comfortable with their current attorney, we do second opinions. I'm here to try to give as much information as I can today, general information, not legal advice. But I'm just kind of explaining some of the issues here that can take place. If you would like to have a second opinion, what you would do is contact our office at 910-509-7145. Today's Memorial Day, so our phones turned off at noon. Everybody's taking a little break, but tomorrow morning we reopen and we could get you booked for a consultation. If people do have any filings, like a copy of an application that was sent out, or if they did get a biometrics notice or receipt, we'd love to see that. We do have our own intake form and questionnaire that we want people to fill out. So that can be a little exhausting to have to kind of start a little bit over with us, but the purpose is for us to try to say, okay, where can we step in? Can we help? Can we enter in our attorney notice of appearance? And if we can do that, great. Then we can basically take over the case. And if there are any amendments that need to be done, we can do that. If there's a lawsuit that needs to be filed, or a congressional or emailed expedite request, that may be something we're able to offer as part of the work we would do when we do the consultation. We'll let you know. And so then sometimes people go, you know what, I'm actually okay with my current attorney. Now I realize there's some other things that maybe the government is doing wrong. Can, like Helen's law firm, can my law firm be on the lawsuit part of it? And can the other law firm stay on as attorney of record? And in some cases, we've been able to do that as well, where our role is really about trying to ram through the system those receipts, biometrics, or bona fide determination, or full T approval decisions. So we're really working on speeding up the case if possible, while the main attorney at the other law firm on the case would be in charge of more case monitoring, or if a request for evidence came up, to be prepared to respond there. So I'm definitely open to different opportunities. One thing we do not do is partner with notarios. Obviously, we do not help non-lawyers and like assist non-lawyers be like notarios or something like that. But if it's another law firm that's been helping you, then they're a legitimate law firm, then we are open to collaborations, because I do believe sometimes there are cases where if everybody works together, we're stronger in numbers, like in that class action lawsuit, which had so far amazing results, even with just the temporary injunction and class action certification. So Fernando, if you or someone else you know wants to contact our office, we'd love to hear from you. And then I'm going to give a quick answer to Sean, who put in a question: will this new memo affect adjustment of status based on the U visa? It should not, because the memo actually does not apply to adjustment of status for U visa cases. And adjustment of status for U visas right now is exclusively within the United States. So it is not a type of case where they can push you out of the United States to complete your residency process without having like a major change in law. So this memo or the president is not in charge of changing the law on who can adjust status through the U visa process. So that's the same basically for T visa, U visa, and VAWA applicants. The new memo saying that like students will need to leave the country to adjust status instead of will need to leave the country for consular processing instead of adjusting status. That's really designed towards other types of applications. But also, I believe that the new memo is unlawful. I fully expect it to be challenged. I do not think that this is something that the government is going to be able to implement legally. But again, you're going to need a bunch of lawyers to be arguing this, because if you sit on your hands and do nothing, then the memo will stand. So I'm hoping that organizations will step up and fight that. Okay, so I'm just going to say a little bit in Spanish about answering these questions as well. Ok, so una de las preguntas del señor Fernando era si nosotros podemos aceptar casos nuevos. Por ejemplo, si el caso todavía está pendiente con inmigración, si nosotros podemos entrar como abogados en el caso pendiente. Típicamente sí, un caso de visa T, un caso de visa U, un caso de VAWA. Podemos hacer una consulta para revisar el caso, a ver si todo está bien. O si hay algo que necesita algún enmiendo. De ahí, si tenemos un acuerdo, podemos entrar en el caso, tener otro contrato de servicios legales para poder ser los abogados con un formulario G28 conectado con el caso. Así que migración, desde recibir nuestro formulario G28, necesitan comunicarse solamente con nuestra oficina legal y no con la otra oficina legal donde terminaron la representación. Ahora, si alguien tiene un problema donde no ha recibido la biometría o recibos del caso, entiendo la desconfianza que puede existir, porque nosotros también tenemos casos donde estamos muy frustrados que el gobierno todavía no nos ha dado los recibos o biometría. ¿Qué hemos hecho para combatir esto? Un pedido de liaison de congresista, un correo electrónico al Servicio de Migración insistiendo que nos manden los recibos del caso o biometría. Y número 3, demandando al gobierno en Corte Federal. Así que muchos abogados están haciendo pedidos con el Servicio de Migración o liaison de congresista, pero si no lo han hecho, es algo que pueden intentar con su abogado, recomendable, o con nosotros si empieza un caso con nosotros. O si entramos como los nuevos abogados en un caso pendiente. Pero también sobre el número 3, somos haciendo como demandas contra inmigración para no solamente insistir que den los recibos del caso o la biometría para las huellas, sino que también estamos haciendo demandas para tratar de conseguir una decisión en la solicitud de buena fe para el permiso de trabajo de acción diferida y también para la decisión final en el caso, si es un caso de visa T. Si es un caso de visa U, entonces típicamente la demanda no es para la decisión final, a menos que su caso fue metido como en 2016 o 2017. Esto es porque una demanda puede agilizar el permiso de trabajo de buena fe y acción diferida, pero no puede moverle en línea ante de gente quienes han aplicado hace casi 10 años. Así que en visas T, el límite de 5,000 visas, nunca hemos llegado a ese límite, pero en casos de visa U hemos llegado al límite de 10,000 visas cada año. Entonces, no pueden como dar mero estatus concreto de estatus de visa U simplemente porque hacemos una demanda, pero para alguien que no ha recibido su permiso de trabajo de buena fe y acción diferida basado en un caso de visa U y el caso está pendiente más de 6 meses, entonces típicamente hay opción de demanda. Y estamos abiertos a colaborar con otras oficinas legales, como por ejemplo ellos siguen en el caso típico, pero nosotros simplemente llevamos la parte de la demanda, o ciertas personas ya no quieren estar con la oficina anterior y quieren mover su caso a nosotros simplemente para que todo está manejando por nosotros el pedido por correo o liaison de congresista y la demanda, quizás todo completamente. Entonces, entiendo la frustración y hubo otro comentario sobre gente casi fallando sus citas de las huellas de la biometría. Si es porque un abogado no mandó la información, esto es como un problema profesional, ¿no? Si es porque inmigración mandó la notificación muy tarde, podría ser algo así también. Poner nuevamente cita de huellas con el servicio de inmigración, porque hemos visto muchas veces que están mandando la cita para la biometría de migración, pero llega a la oficina o a la casa muy, muy tarde. Para nosotros pedimos que todo va a nuestra oficina. Entonces abrimos el correo y la cita es para en una semana. Hay que llamar, mandar un email, un text mensaje al cliente para que estén preparados para esta cita rápido para hacer la biometría. ¿Ok? Entonces, esto en parte es un problema de migración, pero en otras situaciones donde quizás hay mala comunicación entre abogado y cliente, entonces un cambio de representación puede ser una buena idea. Si alguien quiere alguna consulta con nosotros, abrimos mañana. Hoy es Memorial Day, así que empezamos mañana a las 9 de la mañana y el número es 910-509-7145. Otra pregunta era si el nuevo memo, porque hay otro memo que salió el viernes, si este nuevo memo de Adjustment of Status, de ajuste a residente permanente, va a dañar casos de visa U, donde hay un caso de residencia permanente pendiente. Este memorándum sobre ajuste de estatus y tratando de empujar gente fuera de los Estados Unidos para un proceso consular no es basado en la ley de visa U o visa T o VAWA. Específicamente estas tres formas de arreglando papeles migratorios para ajustar su estatus a residente permanente. Si ya fue aprobado para estatus de visa T, hay un sendero a ajustar su estatus a residente permanente. Si ya está aprobado para mera estatus concreto de visa U, ya es un proceso unos años después para meter para la residencia permanente un ajuste de estatus sin salir de los Estados Unidos. Y lo mismo con VAWA, algo parecido que con VAWA hay un proceso de residencia permanente en algunos casos, no en todos. Entonces, la ley para estos tres tipos de casos específicamente da permiso que se arregle la residencia dentro de los Estados Unidos a través de un ajuste. Hay otros tipos de casos donde un proceso consular y un proceso dentro de los Estados Unidos es viable y lo que están tratando de decir es que van a tener que hacerlo afuera si se puede hacer afuera. Yo he arreglado casos de VAWA por un consulado también, pero otra vez generalmente se hace por ajuste dentro de los Estados Unidos. Así que este nuevo memo no lo pienso como un memo que va a afectar los clientes de visa UT o VAWA oficialmente, pero sería un cambio de ley por los congresistas que tendría que pasar para hacer este tipo de cambio. Sin embargo, si vemos cosas como ilegales hechas por el gobierno, ¿qué se hace? Siempre abogados y demandas por abogados. Muchos abogados metidos en todo esto porque hay como, no sé, más de 40 años de residencia permanente hecho en los Estados Unidos basado en diferentes reglas donde se arregla sin salir de los Estados Unidos y están diciendo con un papel que ya no. Y esto, yo pienso que vamos a ver demandas en Corte Federal diciendo que nueva política no es viable, que no es legal, que es fuera del proceso normal y que eventualmente vamos a ver que este memo no va a ser válido. Pero va a tener que luchar para derechos para esto. Okay, and I see somebody just talked to La Señora Luz and made an appointment. That's so great to hear. That's so sweet. So La Señora Luz has worked with us for like 15 years almost. She's amazing. She's always she's always there to help. And I can see she's working overtime today because I was asking if people could do a little bit of phones this morning. But I can see she's working past into lunch. So, of course, not surprised. She's so sweet. I'm always happy to um, allow overtime and give a little extra money, right, of the overtime rate and all these other things if people want to do a little work on the holidays, because I know that's also sometimes the day that it's only people's only chance to call, book an appointment. But I'm just tickled to see that she was there still helping people out. That's so sweet. Fernanda will be looking forward to having a confidential consultation so that we can help you out. Okay, so does anybody else have any questions? I'm glad to see what I can do to answer them. Oh, yep, we've got another one here. Okay, Naveen, thank you so much. So how long for a bona fide determination? I did biometrics in March. This is a good question. So I do have to ask you a question. Are we talking about U visas? Are we talking about T visas? Or another type of case? Because a bona fide determination typically is for either a U visa or for a T visa, and each of those types of applications has a different processing time. And also, some of it is anecdotal, meaning that some of the processing times that are posted officially, sometimes they're not even available officially, but also we're looking at what we're seeing like in our law office. I'll do my best to answer. And then the other thing is biometrics does not control the processing time for bona fide determination precisely. So in part, it is actually when your case was originally filed. So it's the receipt date for the actual U visa or T visa case that we're typically basing our estimate on how long it might take for a bona fide determination to be issued. Um, Biometrics is second to receipts. It happens after. Normally, you cannot get a bona fide determination notice issued or work permit approved based on a bona fide determination notice without having completed biometrics. So if your case was filed a long time ago and you just did biometrics in March, that would be a different answer than if your case was filed a month ago, or sorry, 3 months ago, and you just did biometrics in March 2 months ago. I can tell you that for T visas right now, we're seeing bona fide determination decisions come in somewhere between 8 and 16 months. The last couple that I got were at the 16-month mark. But we definitely had some recently that were at the 8th-month mark, which is why I say 8 to 16 months right now is what we're seeing for T-based bona fide determinations. For U visa-based bona fide determinations, normally it's a little different in our office because if I see a U visa pending more than 6 months, I'm really going to reach out to my client and say, look, do we want to go ahead and do a mandamus? There's a lot of case law. We started suing back in 2018. So we are now 6 years into these lawsuits for mandamus. And so I'm used to seeing how the government reacts to U visa-based mandamus when a case has been pending 6 months or more. So for Naveen, if your case was filed more than 6 months ago and you did biometrics in March, you should be, I hope, mandamus eligible. But I wouldn't be able to advise without a consultation. This is just general educational information. It's just one of the flags or markers for us to begin to have that conversation with people about whether that might be appropriate. But what would be the reasons not to sue? Sometimes it has to do with the quality of the case. So if there's something wrong with the case, I'm going to want to amend it, not speed it up, right? Or if a case is not legitimate, then we have to withdraw it, not speed it up, right? So part of the consultation is just to make sure that everything's probably okay with the application, discuss what it would be like to file a mandamus lawsuit related to getting a bona fide determination or getting receipts and biometrics and a bona fide determination for your U visa case or T visa case, whichever one it might be. So overall with U visa cases, we're seeing something like if people do nothing, like their U visa is just pending normally, they've done biometrics, you might see a bona fide determination within 1 to 2 years. I'm seeing a lot of 19 to 20 months coming across our desks. So If people are coming close to the 2-year mark since they filed a U visa and they still don't have a bona fide determination issued, it's a good time to get this done now, especially right after the class action came through with this injunction, this protective um, uh, injunction for people who have pending U visas and pending T visas and pending VAWA. So, yeah. Um, okay, and so then the next question we're going to answer as a hypothetical. So then the question is, if somebody had a voluntary departure and then re-entered without inspection, and then they later applied for a T visa, could they still be protected? Or if caught by ICE, would they do some kind of expedited removal? So this is a good question. So normally expedited removal is a really specific thing for people who've been in America less than 2 years, or let's just say they're somewhere along the border, maybe within like 100 miles. So expedited removal is typically a border process. It's usually not something that's going to happen much in the interior or for people who've been here for a long time. But maybe the question is also just about like, if you have applied for a T visa, but you had a voluntary departure before and then you came back later without permission, would they like rush you? Would they expedite getting you out of the United States? Or would they try to arrest and deport you in some way just because you applied for a T visa? So my answer to that question is this should not happen under the law for many reasons. Having a voluntary departure, re-entering without inspection, and then applying for a T visa based on being a victim of trafficking, that if you have triggered a reentry bar, if you have a permanent bar under 212A9C under the Immigration and Nationality Act, or you have other bars that have been triggered due to the entry-exit history, those can be waived or forgiven as part of the T visa application process, typically with Form I-192 as part of the T visa application. So immigration violations and criminal history are supposed to be waived or forgiven as part of these discretionary waivers for T visa applicants. So overall, we generally see immigration be pretty good about waiving and forgiving and granting that type of a case as long as we've got all the other factors met for T visa status. But then the other part of the question is, well, if I've got a case that's filed, are they just going to arrest and remove me while it's pending? And the answer should be no. But if they tried to do that, then there is a process for requesting bond. And part of this is called habeas corpus, which is just, let's say, a Latin word that is focused about getting people out of immigration detention and released so they can keep pursuing their T visa case. So whether it was a voluntary departure or a removal order and a person came back without inspection, filed for a T visa, either way, those things are going to be requested on the I-192 waiver application to be forgiven as part of the T visa process. Okay, what are the reasons that you should have protection while you have a T visa case pending in this kind of situation? Again, general information, non-specific advice. Perhaps a person has all kinds of other things going on with their case, so we really can't advise without a consult. But what are the things? Number one, if immigration sees that a case is pending, they are not supposed to just go arrest somebody at biometrics. I know we've seen some news reports on that, and there have been lawsuits related to it. So can the government do something unlawful? Yes. Can you sue the government for doing something unlawful? Also, yes. Now, regarding the protections, if ICE wants to take on enforcement, then in a case with a pending T, one of the things by law under the class action, they must look at expediting the application so that they're not removing somebody just with a pending case, that they're basically giving that person a chance to finish their case. So trying to arrest somebody at biometrics or while it's just pending is really not a part of the current policy by law. But even if they're going by the old policy that was in place until just a few days ago, until this court order came through, they still were not supposed to arrest or deport somebody just because they had a pending T visa application. Instead, they would have to go through what's called deconfliction. That means they would have to go and see First, whether or not any of the agencies that the victimization was reported to would like the immigrant to remain in the United States, because we don't want ICE deporting somebody who might be a victim and part of an investigation. And even if there's no more investigation going on, a lot of the time these agencies are not going to respond to ICE for many reasons. So if they don't respond to ICE and ICE cannot complete deconfliction, then ICE is not supposed to remove the person from the United States. So that's some help under the old memo. Additionally, if you have a pending T visa case and immigration has decided that your case is bona fide and issued a bona fide determination letter, then you have lawful presence and hopefully also work authorization if that was applied for. And with that lawful presence, work authorization, social security number, people are generally going to request a driver's license in their state, so that also helps out as well. Of course, each state law on driver's licenses is different, but most of the times it ends up being a driver's license option. So that just helps people a lot while the case is pending. But a bona fide determination letter has really specific language, and it's awesome language. The bona fide determination letter specifically says that this person cannot be removed. Any stay of order of exclusion, removal, or deportation is listed in the letter. So any removal proceeding, exclusion proceeding, or deportation proceeding is stayed or stopped while the T visa application is pending. So bona fide determination is major protection from deportation while your T visa case is pending. It's one of the reasons why a lot of people have been filing under this administration to get that type of protection. Now, in that big lawsuit I was talking about, there were examples of people who had bona fide determinations who were deported. And the whole purpose of the lawsuit and part of the result so far has been apparently to allow those people to come back to the US. But even before that class action, we saw those kinds of lawsuits happening where people would individually sue to be brought back to the US after ICE illegally deported them, even though they had had a bona fide determination. Okay, so what would be some additional protections with a T visa pending? We talked about how they should not be arresting people at biometrics. If they do, that would be violating due process and also violating protection for victims policy, and also violating the protective order, I believe, that just came in a few days ago. We talked about bona fide determinations and how protective those can be for applicants with a pending T visa. We talked about deconfliction, how regardless of whether somebody has deferred action or bona fide determination, a pending T is still something where they have to do deconfliction before trying to arrest or deport. And also immigration should be trying to expedite any T or U visa case that's pending if a person is detained or they want to detain them so that they have some kind of solution if they have lawful status and they shouldn't be removed. So those are the basics of how things are supposed to work. Okay, what happens if you have applied for T visa status and your T visa case is denied? Well, in this situation, if someone had voluntary departure and just came back eventually later without inspection, and now the T visa has for some reason been denied, we don't know why, the USCIS has a regulation for that. And the USCIS regulation says that generally, USCIS will not put a person into removal proceedings or deportation proceedings just because the T visa is pending or just because the T visa has been denied. What that means is generally USCIS is governed by this regulation to not put people into deportation even if they lose a T visa case. There's an exception. If a person has an egregious criminal history, that means it's got to be really bad, or they're a trafficker or a terrorist, then USCIS could issue a notice to appear for removal proceedings. So it's possible that you could end up with some type of process with deportation if you fall into the category of actually being a terrorist or a trafficker or having some type of egregious criminal history that presumably is on the same level as being a terrorist or a trafficker. So some of the things we've seen in our office, thank goodness, for clients have been things like a deferred action grant based on a pending T, where the case was bona fide. Clients had multiple detentions on the border, or past immigration fraud they had to get forgiveness for, or drunk driving charges. And recently we had one for someone who had all of those things. Now, why would immigration give a bona fide determination and lawful presence to somebody who has immigration fraud, a deportation history, and a drunk driving problem from the past? Because trafficking is still worse. They're trying to stop human trafficking. They're trying to protect victims of trafficking. And if a person like this has come forward and reported what happened to them and they are in the process of a T visa, we want to give them some protection, because at the end of the day, there are people doing far worse things out there. And the person who's applied for the T visa status deserves humanitarian relief, right? Rehabilitation, an important public purpose, or national interest. They've truthfully provided their victim statement. They have good reporting to law enforcement, most likely have been in some type of therapy or rehabilitative program to address some of the alcohol or other issues that they had. So there are really good reasons to give a bona fide determination to somebody who has had a spotted past. So just no judgment here. If somebody has had those kinds of issues, we want to do those consultations. We're here to help people. And at the end of the day, the anti-trafficking program is a wonderful way to help immigrants to move on from the things that have happened to them in the past, and also to combat trafficking. So I hope that answers your question. And if anybody else has another question, I'd love to answer it today. As always, if this has been helpful during this broadcast, you can support our page by sending stars on Facebook. It's a digital gift that helps us improve our program. If you're watching on YouTube, that is awesome. Please subscribe, share our program as well. I have really very few people watching us on YouTube. So if you're there, thank you so much. I really am a little bit more new to social media than I probably should be, but I am trying to do my best to educate more, especially as so many things are changing under this administration. So I appreciate it when people follow. Ok, otra pregunta tenemos en español. Buenas tardes, gracias, saludos. ¿Alguien tiene una pregunta que va a pasar con la residencia para las personas con visa T aprobada? ¿También tendrán que salir del país según el nuevo memorando? No. Este memorando no cambia la ley sobre ajuste de estatus legal basado en visa T para la residencia permanente. Así que tendría que ser algún cambio de ley, no solamente como algo que se escribe con un bolígrafo de la oficina del presidente. Realmente tendría que ser los congresistas que pasen una nueva ley. Además, la categoría de visa T realmente tiene una razón importante para arreglar estatus de residente permanente sin salir de los Estados Unidos, porque tiene que ver con gente que ha sido parte de un reporte de trata de personas o quizás alguna investigación podría haber sido, y entonces no tiene sentido mandar a esa gente fuera de los Estados Unidos para cumplir su proceso. De hecho, no existe un proceso para ajustar su estatus fuera de los Estados Unidos basado en la visa T. Hay opción de procesar por el consulado americano una visa T para esposo o niños o derivados, pero la primera solicitante con visa T1 tiene que estar aquí para estar aprobado para estatus de visa T, y también todos tienen que estar en los Estados Unidos y aplicar para su residencia permanente para ajustar su estatus a residente permanente. Así que el proceso consular conectado con la visa T no es un proceso consular para residencia, es solo el proceso consular para la visa T, y solamente es para si alguien estaba aquí como víctima y tenía su familia fuera de los Estados Unidos y lo trajimos con visa T, como derivados del caso. Yo sé que hay mucha confusión y miedo, y voy a ser honesta, yo pienso que cuando hicieron este anuncio deberían de haber sido muy específico en lo que habían hecho. Solo poner este papel antes de un fin de semana grande como Memorial Day fue para asustar a abogados, fue para asustar a gente con solicitudes pendientes. Esto no fue aceptable en mi opinión, porque no tenía suficiente información y tampoco no acordaba la gente del proceso de ajuste para muchas categorías. Es solamente hecho por ley en los Estados Unidos. y que lo que estaban diciendo no aplica a estos. Yeah, estoy muy feliz que hizo esa pregunta y espero que ayude a otros. So, I'm just loving the comments here. Fernando, you're cracking me up. That's so awesome. Thank you for asking your questions generally. Now, again, in the consultation, I may have different answers for you because I'm going to want to see your file. It's going to be confidential. Here we're talking today about hypotheticals, but I'm glad that on Memorial Day you had a chance, to ask some questions generally and get a feel for like who we are and the type of work that we do. That is awesome. I just love it. Every time I do a Facebook Live, like people are so awesome and the questions you ask are awesome. And I just, there's just not okay, philosophically, people can be out celebrating right now. They could be out observing Memorial Day related to people that they've lost in their lives. You could be hanging out at home, watching TV, or, maybe spending some more time working, or I don't know what. But instead, you're here trying to get legal information and becoming educated about the American laws. And that's just so patriotic. I love it. I love that people want to learn about the law. They want to get information. I know it is important to being in the United States. I know it's a part and parcel of being able to work and, to andar más libre and all of this. But I just really admire that people are out there really trying to learn and do the right thing and get information from attorneys and learn as much as they can so that they can hopefully, get the immigration benefit and also be able to help others. So just thank you so much for wanting to be here today and talk about immigration. A lot of my friends are immigration lawyers too, and we talk about immigration all the time, theories and strategies and all of that. But I just love it when other people, non-lawyers are interested in this topic as well. So thank you. You always make the program really interesting. So does anybody else have questions? I don't think I've missed any here yet. If anybody has one, please throw them in. No sé si alguien tiene más preguntas, puedo contestar una pregunta más. Y si no hay más preguntas, entonces voy a simplemente hacer un poco de resumen de información que yo quería pasar, pero voy a esperar un rato a ver si alguien tiene una preguntita más. Y como siempre, nuestro número de teléfono es 910-509-7145. Soy la abogada Helen Tarokic. Ahora, información sobre certificaciones de visa U. Importantísimo, porque veo que y clientes y abogados hacen errores sobre teoría de certificación de visa U. Esto es muy importante. Si alguna agencia policial ha dicho que no quieren firmar, esto no significa necesariamente que la oficina del fiscal, como prosecutor, solicitor o district attorney, esto no significa que ellos no van a firmar. Yo aprendí esto en una manera difícil. Yo estaba como en argumento combateando constantemente con alguna oficina local de la policía, del departamento de policía. Hasta un punto que yo pensé, esta gente ignorante jamás van a entender lo que estoy tratando de decir, no importa cuánta información les mando, no quieren participar en un programa de visa U. Realmente como frustrada. Y entonces un compañero me dijo, ¿por qué no pides a la fiscal? Es muy inteligente. Y la pedí y 2 semanas firmó la certificación de visa U y podremos aplicar para nuestro cliente. Yo aprendí que los fiscales muchas veces tienen más capacitación, más tiempo y también ellos pueden certificar aunque la policía o sheriff no querían. Igualmente, en ciertos estados, no en Norte Carolina, pero en otros estados, un juez puede firmar una certificación de visa o depende de las reglas estatales. Así que si alguien ha tenido la experiencia en que la policía o sheriff no quieren certificar o la fiscal no quiere certificar, esto no significa que no podemos considerar preguntando a otro tipo de agencia que tenía la jurisdicción en la misma situación. Encima de esto, otro error que hemos visto de clientes y de abogados cuando nosotros averiguamos que se puede hacer es en situaciones de asalto sexual. Muchas veces la gente considera esto como que si no hubo un reporte o si no hubo como una firma de certificación de visa U, que entonces no hay ningún caso. Pero muchos casos de abuso sexual son conectados con trata de personas sexual. Y las definiciones, las reglas y todo eso bien complicados, quizás demasiado para este video hoy, pero lo que quiero decir es si alguien tiene una situación de abuso sexual donde nunca reportaron o no fueron certificados para la visa U, por favor que consideren una consulta para ver si puede hacer la visa T, porque hay un nexo. La visa U es diferente que la visa T, es diferente que VAWA, pero hay ciertas cosas entre las tres diferentes opciones que son algunas cosas de vez en cuando parecidas, o por ejemplo algo de violencia doméstica puede ser para la visa U, o quizás califica para VAWA, o de vez en cuando es la coerción para un caso de visa T. Así que parte de la consulta extensiva que hacemos y la razón que hablo demasiado es porque estoy considerando diferentes opciones, cuál sería mejor o una combinación de dos opciones para ver qué se puede solicitar. Así que espero que esto ayude. Si alguien ha tenido un problema en conseguir una certificación de visa U o ha tenido alguna denegación de la certificación o una denegación de caso de visa U o caso de visa T, estoy muy interesada en esto. No puedo prometer resultados, no puedo hacer ninguna garantía, pero yo estoy muy interesada en evaluar esas opciones, a ver si en un nivel más alto hay alguna manera de arreglar o demandar o apelar o pedir algo localmente que se arregla usando lo que se llama advocacy, como tratando de advocacy, realmente tratando de usar y más información y educación generalmente con diferentes agencias o departamentos para tener éxito. Eso es algo que me encanta hacer. Y un anuncio final, tengo un libro que voy a publicar. Nosotros estoy esperando que el libro de Vístate va a salir al final de julio, vamos a hacer más anuncios de esto. Ok, dos más comentarios. Gracias por su comentario. Realmente sí me preocupo para su comunidad porque es mi comunidad y yo creo en el poder de los Estados Unidos. Yo creo que inmigrantes son la fundación de nuestro país y todo bueno viene de eso. No estaría un país muy fuerte sin tantos años de tener inmigrantes como el base, la fundación de todas las cosas buenas. Así que realmente es un honor poder hacer el trabajo que hago y mis padres son migrantes también. La pregunta es, buenas tardes, en estos tiempos es bueno hacer una moción de una moción to reopen como una moción de reapertura, una deportación en su ausencia. Se envió mi caso de visita en junio 2024 con firma electrónica. ¿Será que lo niegan por eso? Eso es una excelente pregunta. Ok, me encanta esta pregunta, pero sí, como siempre, una respuesta larga. Ok. Parte de la pregunta es, si es un buen momento hacer una moción de reapertura de la deportación en ausencia, si el caso de visa T sigue pendiente. Ok, de vez en cuando hay razones importantes hacer la moción de reapertura antes de que se apruebe la visa T. Un ejemplo sería si alguien ya tiene sus citas de chequeo con ICE y por eso ICE está diciendo, si no te mandas como esta emoción, en la próxima cita te voy a deportar como algo no muy bueno, algo asustoso, algo que quizás no está correcto, pero es una situación para evaluar con su abogado a ver si realmente hay que tratar de abrir la deportación antes de la próxima cita con ICE para parar una deportación. Pero normalmente en tal caso, en un caso donde tenemos este caso de visa T pendiente, no voy a hacer la moción de reapertura hasta que la visa T está aprobado, porque hay ciertas reglas sobre esto de que haciendo la moción de reapertura, cuando un estatus de visa T ya está aprobado, entonces la persona ya no es deportable. Hay diferentes reglas que nos da como más derechos quizás a abrirlo. Pero en otras situaciones quizás hay alguna excepción y vamos a querer hacer la moción más antes. Así que depende del caso. Pero otra parte, se envió el caso de visa C en junio de 2024, así que ya estamos casi a 2 años desde que esa petición fue metido y hoy en día migración es diciendo, ok, 6 meses más quizás. Para 80% de los casos están tomando 30 meses y media. Si su caso ya está pendiente 24 meses, tiene como 6 meses o 7 meses, quizás más si los tiempos de procesar no cambian mucho. En tal situación, si no tiene su carta de buena fe, permiso de acción diferida o aprobación de estatus de visa T, o si tiene su permiso de buena fe y todavía le falta estatus de visa T, hay opción posiblemente de hacer una demanda como un mandamus en Corte Federal, ¿ok? Para agilizar la decisión final. Porque cuando alguien está sujeto a una orden de deportación, tiene y más razón de mandar al gobierno para agilizar un caso lento. Pero ha comentado aquí que la firma es electrónica. Hace un tiempo hubo problemas donde gente estaba firmando electrónicamente sus formularios. Y durante la pandemia hubo ciertas políticas y de ahí ellos querían cambiarlo y hubo muchas diferentes situaciones. Y entonces algunos donde han firmado electrónicamente, no a mano, recibieron denegaciones. Así que hacer una demanda de agilización en un caso de visa T, cuando hay una firma electrónica, podría quizás hacer un poco de problema simplemente porque no queremos como una denegación de un caso simplemente por la firma electrónica, ¿no? Si agiliza algo, puede ser agilizando la aprobación, agilizando la denegación o agilizando el pedido para más evidencias. Ahora, ¿qué pasó sobre estas firmas electrónicas? Muchos diciendo, esto no estaba bien, tal abogado es bueno, tal abogado es malo, como muchos comentarios, entiendo esto por las redes sociales. En nuestra oficina, nosotros típicamente usamos como una firma con bolígrafo y lo escaneamos y así lo mandamos a migración o una firma con bolígrafo nuevamente y mandando los originales. Así que yo no usaba como la firma en los formularios electrónicos, pero hago clases. Soy parte de la Asociación de Abogados de Inmigración. Yo estaba vigilando lo que estaba pasando y de vez en cuando recibimos un pedido de migración para confirmar diferentes firmas y cosas así. Ok, ¿qué pasó? Entonces, hubo demandas. Hubo demandas de abogados contra inmigración diciendo, oye, no puedes solamente denegar este caso simplemente por una firma electrónica. Si quisiste rechazar un caso, está bien, dame otra chance para mandarlo, pero no esperes 2 años para decirme que la firma no está bien, porque hay contratistas para inmigración que reciben y abren los paquetes y pueden ver si es electrónico o no. Eso fue el momento, no 2 años después o 3 años después o 1 año después. Y de lo que tengo entendido, estas demandas han funcionado para abrir estos casos y darle una nueva chance de firmar para poder ganar su caso. O simplemente abrieron y aprobaron los casos, depende de cómo salió el litigio. Así que si alguien tiene esta situación, no se da el vencido. Yo tendría que hacer una consulta específicamente para decidir si el caso todavía puede ser aprobado. Voy a querer mirar las firmas y también confirmar que mi cliente entendía o la cliente nueva entendía qué es lo que estaba firmando. Porque cuando hacemos una consulta, yo quiero confirmar que la declaración de víctima es correcta, que no hay algún amiendo que se necesita hacer del caso pendiente. Queremos solo doble chequear que todo está en orden. Pero si la única cosa es de la firma electrónica, quizás estar listo para meter formularios nuevamente como firmado de diferente forma. O si va a ser una demanda de agilización, entonces también tiene que considerar que podría ser un pedido de más evidencia sobre si está asistiendo a terapia, si ha firmado su carta de declaración de víctima, pueden pedir para los formularios que sean correctamente firmados nuevamente con un intérprete si fuera necesario. Hay otra opción también que gente ha hecho donde han metido un nuevo caso un poquito diferente, pero básicamente lo mismo, pero poner al día la información de terapia, quizás cambiar un poco del argumento legal, porque hubo reglas nuevas que salieron en agosto, unos meses después de que usted metió su caso, así que hay ciertas cosas que serán un poco diferentes, pero mandar un caso nuevo de visa T, tener esto pendiente para que para esto todavía puede obtener una carta de buena fe, mientras intenta su demanda quizás para estatus de visa T, y de cualquier de estos casos, si lo gane, entonces empezar con abrir su caso de remoción. Otra vez estoy adivinando. Tengo siempre muchos planes en mi cabeza sobre qué se puede hacer, pero todo tiene que ver con mirar el archivo, el historial, entender mejor de todo lo que había pasado. Solo queremos que si vamos a entrar en un caso, si hay algo para corregir, lo podemos corregir. Pero he visto muchas veces que el caso está bien y solamente hay ciertas cosas que se tienen que en que se tiene que trabajar para seguir adelante. Espero que esto ayude y si quisiera una consulta con nosotros, está bienvenida. Pero también sería bueno si quisiera hablar con su abogado de lo que nosotros hablamos hoy, a ver cuál es su opinión legal, ¿no? Muchas veces conocen el caso muy bien y entonces es un buen momento hablar con ellos directamente, ¿no? Siempre tener esta comunicación puede ayudar. Ok. Otra pregunta, ¿qué pasa cuando se hizo una demanda mandemos y lo mandaron con el juez para la decisión final? ¿Cuánto se tarda el juez en contestar? Oh, buena pregunta. Oh, estoy peleando esto todavía para algunos. Depende de qué tipo de mandemos. Hubo una regla que salió en agosto de 2024 y nosotros demandamos al gobierno para nuestros clientes para pedir una carta de buena fe y permisos de trabajo, porque yo había hecho mandamas antes para este mismo tipo de caso y dentro de unos 2-3 meses los clientes recibieron sus permisos o por lo menos la carta de buena fe. Y de ahí, en esta demanda grandote que hicimos, de ahí el gobierno estaba demorando mucho. Y entonces saber cuándo vamos a recibir este tipo de decisión del juez es difícil saber. En otros casos que fueron metidos después de agosto 28 de 2024, hemos típicamente recibido alguna respuesta un poco más rápido. El gobierno tiene 60 días para responder, pueden obtener una extensión de 30 días, típicamente casi automáticamente, y de ahí es ver qué va a pasar con un juez. Es como también, es difícil porque depende de en cuál corte está pendiente el caso. Y para poder contestarlo yo tendré que mirar como ciertos archivos. No lo sé como exactamente en este momento cuánto tiempo más podría tener que esperar. Lo que he visto en casos de demanda sobre casos de visa T es que el tiempo de procesamiento del gobierno sigue subiendo. Hace unos meses, cuando yo estaba escribiendo mi libro, puse que el tiempo es 27 meses. En el otro borrador el mes siguiente, tengo que cambiarlo a 28. De ahí cambiarlo a 28 y medio. De ahí 29 y ya 30 meses y media. Y entonces es muy frustrante porque cuando hacemos un mandamus, esto puede ser demorado también, pero imagínense sin esto, cuántos chances tenemos para moverlo. Así que si siguen demorando más y más y más, aunque la mandemos, espera un juez, una decisión o algo así, entonces es como una otra situación. Ahora, tengo un mandamus donde metimos el caso hace un largo tiempo para nuestros clientes y el juez ya va a tener ¿cómo se llama? Una audiencia el 2 de junio. Y si esto va bien, yo pienso que va a tener un excelente impacto en todos nuestros casos de mandamus. So podría ser, depende del caso pendiente, que vamos a tener mucho más información ya para el final de junio si el argumento legal se hace en la audiencia con este juez federal el 2 de junio. So, wish us luck. Estamos trabajando en todo eso. Okay, so otra pregunta. Okay, a person has a T visa process pending for 15 months, no BFD or work permit yet. Oh, you're in another one of these situations. So I have seen T visa bona fide determinations with the work permit issued between 8 and 16 months. The last two that came in were at the 16-month mark, and that included people with a detention and criminal history. So it wasn't like a super clean case, but we still had it come in within the 16 months. So again, hard to guess because I don't know what's going on in your case. We're always looking at, is there a properly signed victim declaration? Are the forms properly signed? Were the correct forms included? Were the forms not expired? Have background checks been run, like biometrics for the T visa case? Did anything pop up that was the problem? Have you received a request for evidence? But if you haven't had any problems and the case has just totally been pending normally, then normally what we're going to see is within this 16-month range, you may actually get an answer. So 15 months, it's like you're almost there. But I'm so afraid that if I say 16 months, that the next one's going to be 17. And I had one where it wasn't until they were granting the T visa that they gave the bona fide determination. I was like, this is so unfair. Why couldn't they have given this a year ago while my client was waiting on their T? Getting the bona fide determination at the very end of the process is just not fair. But if a process is going to take, okay, good, no RFE, that's great, good. So if the process is now taking 30.5 months officially according to USCIS, and yours is at the 15-month mark, then you're probably getting a little bit closer to getting some information. Now, a couple of tips. If you have a I-765 work permit pending under category C40, that's the T visa bona fide determination work permit category, not the full T visa approval category for that work permit, but the bona fide determination work permit category is C40. You should be able to plug in your I-765 status online and access that. It'll probably just say something like fingerprints have been processed or the case is pending or when it was received, if there's nothing new going on. But if you're not getting automatic updates from USCIS, I do think it helps a lot of people. You can talk to your attorney about it if you want. You can also just go to USCIS's website and check the status of that pending I-765 to get updates. Try not to check it every day or you'll go crazy, but maybe once a week, mark your calendar. I know some people check it every day. They can't help themselves. And again, I'm not here to judge, but I just always worry about people stressing. So what we do in our firm is we set up online tracking. So anytime there's action taken on something that's trackable, immigration is supposed to send us an email on notifying us of the action in the case. That also makes me crazy because I'll get notices like fingerprints have been applied to this application. I'm like, okay, great. They did biometrics, but I'm like, oh, maybe it's an approval. And then I'm like, oh, they just processed fingerprints again. So yeah. And fingerprints reused. Okay, good. So that's nice. Fingerprints reused I like because oftentimes, again, I'm guessing, not advising, but a lot of times when fingerprints are reused, it probably means also maybe fingerprints weren't an issue before. It didn't trigger any request for more information. So that's nice too. Okay, hi, thank you so much, Mr. Patel, for checking in with us. It's always great to see questions. Does the T visa approval have to go back to his country to get a green card process done? No. So the law says adjustment of status is for T visas inside the United States. There's not even a consular process to do this. There's not a process to go to the U.S. consulate in Mumbai or Delhi or whatever for a green card process. So the green card process for T visa holders and U visa holders right now is exclusively in the United States. And if somebody wanted to change that, they would actually have to pass a new law. And I can't imagine Republicans and Democrats getting together and making that the new law they pass. They can't agree on a lot of things as it is, but it would make absolutely no sense to have people consular process for a green card based on a T visa or a U visa outside of the country. And that memo that came out on Friday, right before the holiday weekend, does not implicate people with a T visa adjustment of status process. So now, if we see new memos or new guidance or a new law or something like that, we'll definitely post. We'll definitely set up an informational session. But I don't see anything here about changes in law. And let me actually, while we're on here, I'm just going to pull up the adjustment of status. Let's see if we can get this one. Give me just a sec. Yeah, from the May 21, 2026 memo. So what they're trying to do here, let me go to the right page. Yeah. So one of the things that they're looking for is adjustment of status under certain statutory categories. And then our categories for adjustment of status for people who are adjusting through a T visa or through a U visa are sections M or L. We're not talking about a 245A or C type of adjustment process. I think I got the statutes quoted there correctly. But the guidance is where consular processing is available to a person seeking adjustment of status. They now want that person to adjust outside of the United States. So then also, let's see, I'm going to give you just a second. Yeah. So they're really talking about other different categories here. And again, a lot of the law that they're citing here is really something that I think is being misinterpreted to begin with. So for people who are looking to adjust status based on, oh, hi, Fabian. Thank you for joining us. You are so sweet. So for people who are trying to adjust status based on a T or U, this really is a process that is meant for inside the United States. It's not a consular process, which makes sense because, again, these are humanitarian options. And they're also the type of option that can be approved for somebody who doesn't have a passport. It can be approved for somebody who doesn't have permission to return to their home country, whereas certain consular processes are really available to people in other categories. A lot of it's like employment-based processing, but that's another reason why I think that memo is going to be really challenged because we're talking about more than 10,000 immigration attorneys who I think are going to be hopefully on top of this for their business immigration clients and for their marriage-based clients and that sort of thing. So I hope that this will all work out. As we have another Facebook Live or we get more information, I will post to Facebook. I know it's all very new information, but for right now, I think that we're okay how we are and nothing has changed in the T or U visa law related to green cards. So it's just so great to see this many people watching today. Thank you so much for all your awesome questions. We will get this video up on YouTube. I mean, it's streaming now, but save it so people can access it later if they want to do a replay. I'm sorry I didn't do as much in English and Spanish, vice versa, as I wanted to. It was a little bit more challenging than I thought it would be, but I did my best. And then also it'll be up on Facebook for a while as well. And then we'll try to get some clips put out there as well through Opus. So thank you all for watching. Gracias por toda su atención, sus preguntas fantásticas. Realmente le agradezco mucho su paciencia con las preguntas. Para gente quienes son nuestros clientes, si está mirando esto, yo sé que es muy frustrante. Me encantaría que sea más rápido todo el proceso. entiendo que gente tiene miedo de este proceso, así que si tienen preocupaciones, estamos aquí para poder contestar. Si son clientes también y nos miraron hoy y no podría contestar específicamente su pregunta, por favor que nos mande un correo electrónico, podemos chequear en nuestro sistema para contestar específicamente qué es lo que estamos anticipando hoy sobre un tiempo de procesar o de alguna corte o algo así. So, le agradezco mucho, que tengan un buen día. Oh, so nice. Thank you all so much. Please like, follow, share. We'll see you on the next thing. Take care.